Is really just as chair, and I don't intend saying very much at the beginning. If there's some time at the end and there's some questions and I think I can add to the answers that the speakers give, I'm happy to do that. I've made a few notes about things, but a lot of what I was going to say is from what I can read from the slides, covered by the slides, but there might be some other things, some other tips that I might be able to give after the speakers have had their say. I just checked with Steve and my recollection was that there wasn't any consultation by the Chief broadly in the implementation of this practice direction. That's not an issue or a problem. Certainly there was a practice direction, I think, or some attempt at introducing this, or it was introduced in the Sydney Registry some time ago for maybe not obvious reasons to people who aren't from Sydney, but the practice in Sydney is somewhat different to Brisbane. It's certainly up here where applications are filed quite regularly, argued viciously, many documents, and so it was introduced there with limited success, I think. But this is obviously more broadly because it's across the country. Having said that, we weren't consulted about it. Generally, I think the judges of the court support it and are very happy is not the right word probably, but pleased that it's been introduced because duty lists are just becoming ridiculously long. Our matters, as you all know, are becoming more and more complicated. We very rarely get the matter now about an argument about a Monday morning finish or a Friday morning start. They're much more complicated. The lists, as I said, are longer, and something like this is, I think, a really important tool. And as practitioners, maybe the point of it was, but the benefit for all of you is that it just continues to send, hopefully, the message over and over and over again every time we prepare an affidavit. Focus on the issues. Well, identify the issues, number one. I've been saying this for 35 years. Many people in the room have heard this. The speakers have said the same thing when they've spoken and no doubt at other conferences and when they've been talking with their clients. So identify the issues, limit the material to those issues. The speakers will talk more about that. So that was really the point of it, or the hope that it will help people focus. Like any rule or direction or practice direction, different judges will approach it in different ways. We've had some conversations about, as a group in Brisbane, enforcing it, as strictly as we possibly can. There are appropriate exceptions built into the practice direction, and I know that speakers will talk to some of those things about the types of applications that may fall within the exception, but we will try very hard to enforce it. And as I said before, some judges will do that probably more strictly than others. But part of this whole process, even with this new practice direction, and I know one of the comments that are made in the slides is you've got to know your judge, and this is no different. You've got to know the judges that will impose it strictly. You've got to know the judges that might be inclined to make cost orders against practitioners, and that's part of the practice direction. And I suspect that there'll be some that will do that more often than others. So again, know your judge, and I think that's all I need to say at the moment. I'll say some more later on.
Good afternoon. Thank you for coming here on a Friday afternoon. I know that's not the choice time, but it was picked specifically so that we could ask Judge Spellican to come here, knowing she had a duty day today. And of course, thank you, Judge, for making yourself available. And your time is very precious. I'd also like to acknowledge Judge Middleton hiding up in the back, from all the way up from Newcastle. Come on in. Sorry. We're not going to ask him any questions, so.
I don't know.
He hasn't been put on notice, he tells us. And Robin and I'd also like to thank Pippa for making this space and putting on some nibblies for us all. Just briefly, we're presenting this as the mediation clinic. There's the four of us, but it's myself and the very windswept and debonair Robin Slade-Jones that are presenting to you today. And we're trying to make ourselves available to various other regional registries. I did a talk for Judge Coates down in Lismore, together with Jen and any other judges, of course, that would like to have us talk about the new practice direction. We're ready to go. Once you've all had the slide distributed to you, Robin and I, it didn't escape the irony, or we thought it would be ironical for us to prepare a 30-page. You know where I'm going with that joke. Next page. So, being distributed out as well, if you haven't already seen it. Is everyone okay? Getting the pens out as well. I don't know why you just don't all have iPads. 2018. The citation obviously is the practice direction number 2 of 2017. Right back there, ladies. Good. Thank you. As you all know, as you've probably all heard about it, it's probably referred to in the shorthand as the 10-page practice direction, but it is probably a little bit more detailed than just you can only file a 10-page affidavit. Probably the more important part of the practice direction is that the first return dates are going to change from what we're used to. How it's going to change, it's a bit of a watch this space, and that's why we've tried to ensure that Judge Pelican is here today so that you can ask those questions about how, as you heard, how strictly the judges might adopt the 10-page rule, but more importantly, what are the expectations on that first return date, what is going to run and what's not. You're probably also aware that the Family Court has also recently handed down a practice direction. It's not in a similar vein as this, except you now can't file annexures or have exhibits in your affidavits apparently. So. But we're here to talk about the Federal Circuit Court. As the judge just mentioned before, this has been piloted or trialled elsewhere in another registry. I have no knowledge of how it went. And again, as the judge said, this has been brought about by ultimately what are resourcing issues. There's just too many matters, not enough judges or judge time available to get through all the matters, so something needed to change. I've put in the slide, I think we also had it coming to us as practitioners. A couple of years ago I put out a blog and some people commented on that and said I was just getting old and cranky, but the reality is I think our advocacy skills have needed some refining, particularly on the day when we go to court, about what we stand up and say and what we try to achieve on those first return dates, but also the material that we were filing. Something had to change. We needed to lift our game, and that was 2 years ago, but the Chief Judge has done something about that, hasn't he? All right, thanks. So you all know that it came into operation and commences operating from the 1st of January, so any new application in a case, it obviously applies to. It obviously applies to an application in case for a matter that's already in the court list. So if you filed your initiating application last year and you're bringing on a fresh application for something new, one would hope, it applies to that application as well. So, when does this practice direction impact you and your practice and your clients? Our view is it starts as soon as they walk in that door. As soon as your client walks in your door, you need to start thinking about what is the main thing, and asking the client what is the main thing that they need resolved. And the same for an existing client. If they're saying, "Oh, something's happened," what is that urgent change, and what are they going to try and achieve by making an application to the court? Now, one would hope that you only do this after you've exhausted alternative dispute resolution. Obviously, you've got to go through the Section 60I certificate, but what we're very passionate about is that you start to approach your ADR or your advice to your client to go and pursue ADR, and linking in your client with an ADR service to a service that is very proactive, that they really try to get to the bottom of what's the immediate thing that needs to be resolved. So what am I saying there? For example, a parenting dispute, you're acting for a parent, say it's the father, and he hasn't had any time for eight weeks. Usual kind of scenario that's pretty not uncommon to most of us. You're not going to send them off to ADR to try and solve the parenting crisis until the child turns 18. I think you need to really start to refocus right at that time, saying, listen, we just need to get the time started again. Because it will be no good showing up, in my view, on the first return with still no time happening. Because if the court, if you can ask Judge Spellican to make some time orders, that will be a feat in itself on that first return date. But your case is so much more advanced by the time we do get to that first return date if something's been happening. All right? Any queries about what I'm talking about there? There seems to be nods. Sorry, Robin. It becomes very important to ask the client, what do they need to happen right now? What's the most important thing to them? And it becomes even more important, and this is where I think we as practitioners really need to change or refocus. We need to start being brave. We need to be able to say to our client, you're not going to get that happening on a first return date. It might be achievable in 6 months' time or 12 months' time, but it's just not going to happen on the first return date. You need to be brave, because it's too late once you're standing up in court and told, no, nothing's going to happen today, but I'll send you off for an 11F report. Your client will be disappointed. So be brave. Any disputes with what I'm saying so far, Joe?
No, I totally agree with you.
So, probably what you're really focused on is how do we tell our story, or our client's story, in 10 pages or less. That's probably the important part to start with of the affidavit. There's questions of interpretation, in my view. Within 5 minutes of me sending out an email, hey, here's the new practice direction, I got a response. Is it 10 pages plus the annexes? Or 10 pages including the annexes? And with the practitioner involved, I was very tempted to say it includes so, thinking about your affidavit, you need to focus in, as the judge just said, what is the issue and what are essentially the elements that you need to establish to support that application that you're going to make. So for example, if your client has done the bolt, so to speak, and they want to relocate urgently on an interim basis, you need to look at Morgan and Miles and make sure that affidavit has clear, and you focus your affidavit on the clear emergent or urgent circumstances that have arisen to I don't want to use the word justify, but to support that urgent relocation. Same with recovery orders. You know, you have to be precise and set out, this is the time that I was spending and this is what's happened in terms of the child not being returned to me. The interim property side of your applications, you're going to need to be even more focused. I don't think you're going to get interim spousal maintenance running on first returns. That's my personal view. Judge Middleton's in the back of the court nodding at me. Judge Spellican's nodding at me. But I also think, or we also think, that if your urgent application or your initial property application includes the funding of an ADR process, including valuation, and meeting your legal fees to an ADR process, and that you're very precise as to why you need that. And Robin's going to give some examples later in the slide of what we think would be an appropriate way of addressing that in an affidavit. That's what you need to do, but you need to think about what's the case. What does Strahan's case say in relation to litigation funding or interim property? We've also said in the slide there will be, and your notice of risk is even more important. Don't use the old quick way of going through your notice of risk and saying see paragraph R, see paragraph 8, see paragraph 9. That in my view is really not good enough, and it's not helpful, because most of you know those notices do go to the department, and that's not going to help a department officer go through the notice of risk and maybe not have the affidavit to cross-check that with. But also, that's your client's evidence, so your client's evidence about risk must be very clear. How we particularise that in affidavit, again, is something Robin's going to be doing for me. Thanks. Okay, so the don'ts. I'm going to play bad cop. Robin play good cop. Don't cheat. Okay, you've probably got a circular from Flipper recently, but there are rules apparently in our Federal Circuit Court. One of them is right at the start. Most of us miss it. It's Rule 2.01. Left side margin 30 millimetres. All other margins 10 millimetres. Font is 12-point font. I don't know how many briefs I get, but 8-point. And 8 millimetres between lines. Believe me, this is what people are now trying to do to get around this practice direction. Smaller font, single line spacing, no margins. So don't cheat. The other thing, it's not necessarily cheating, but I have seen, and I saw it as recently as Tuesday, an affidavit that annexed as a bundle correspondence between lawyers from dun to dun. Now, if it's from the start of the matter to where you are now and it's that thick, that's not meeting the spirit, I think, of the practice direction, and you might have a problem with your judicial officer, if not the registry. But if it's a short bundle of, say, 5 letters, and there is a preamble paragraph to explain what those letters go to, well, that's probably appropriate. I say don't waste words in your affidavit. We were married on this date. We separated on this day. We had these children, and so on and so on. That's already in your application. The initiating application has all those dates. So you don't need to waste your words. State on the first 2 pages, setting all that information out again. Avoid all the legal palaver of coveralls and catch-alls, all the facts here interposed to. I don't think you need that anymore. You know, it's just a waste of words. It's an affidavit. You've sworn it, or your client's sworn it. Don't put in headings. We all know well, I'm pretty sure the judge that you're appearing before will know what relevant section 60cc factor a certain paragraph relates to. You don't need to put a heading above it. That's just wasting paper. It's going to happen, and this is probably one of the biggest bugbears of all judicial officers, because it's a bugbear of barristers. When we're reading briefs, comment, submissions or arguments, it's not evidence. It's just simply not, and it's just unhelpful. Just stick to the facts. Get your client to tell you what happened, what are the particulars. Robin will give you some tips on how you elicit that from a client, but it comes down to who, what, when, where, why. That's all you have to ask them. Don't just get your client's email and cut and paste it in with all the lovely tiptoe through the daisy story about what happened and so on. There might have been domestic violence during the relationship, but if you're there on an interim or a Strahan type order, what's the relevance on an interim application? Okay, It doesn't need to be in there. Increased focus on the use of your financial statement, particularly if you are there on interim property orders. Make sure they're accurate, and don't leave your client to fill that in. And the last thing I have there is be really careful about the use of annexures. My view is the practice direction doesn't limit you to one affidavit. Cheer squad affidavits are pointless on an interim application, but an affidavit from a treating medical practitioner is important, and it carries more weight. It would be a submission that I would make to a judge that medical practitioner has also sworn an affidavit attaching it to his affidavit, rather than it being to whom it may concern attached to the back of your client's affidavit. I mean, that medical practitioner may have no idea of what his or her document was being used for, and might have a different opinion. Okay, so first-hand evidence is always best. Avoid hearsay, even though you're allowed to perhaps. I'm standing down, letting Robin talk. Is that all right?
Windswept.
And debonair.
Yeah, but windswept. What I want to do really is to give a real life example of something that happened to me in the UK quite some time ago. It is relevant, and it's relevant for these purposes. In 1993, I was a baby barrister, and my head of chambers approached me and said, "You're in court tomorrow. You're in the High Court in the Family Division. It's just a directions hearing." Yeah, that was the lie. So off I popped to the Royal Courts of Justice in London, and I'm up against a man who took silk the following month. I was scared, and I was in front of a judge who naturally knew his stuff very well. So the questions were these. Mr. Slade Jones, I understand this is an allegation of sexual abuse. Yes, my lord. I understand that there is no paediatric evidence. Yes, my lord. No, my lord, perhaps. I understand that there will be no further independent evidence. That's right, my lord. Put her in the witness box. And there it was. The trial had commenced. The trial of the issue had commenced. Relevance? Can you imagine how I felt when I was able to say, "Ma'am, you filed an affidavit in these proceedings," sworn statement over there, but it really doesn't matter. And I had the confidence. No, I had no confidence at all, I'm telling you. But I was sitting on something incredibly strong, which was a document about 6 or 7 pages that set out my case perfectly. Ma'am, I understand on a certain date you saw a certain document. Are the contents of it accurate and true to the best of your knowledge and belief? Yes, they are. My lord, I have nothing else, and I sat down. My job was done. But it was done for me. It was done for me by some clever solicitors. And that's the point of all of this. None of this practice direction should come as any surprise. It doesn't come as a surprise to me, and indeed I welcome it. Because I'm tired of standing in front of judges on a Friday afternoon when judges are tired. A little over it, frankly, and it's just before Christmas. We've all been there, we've all experienced it. And I've got a 30-page affidavit, most of which is inadmissible, or perhaps these days admissible, but very little weight to be attached to it. And I've got to say, Your Honour, starting at paragraph 423, you're on the back foot immediately. So what's the cause of all of this? I think really perhaps the amendments back in 2006 started the rot, really, where the rules of evidence were kicked out, really. Of course you can ask for them to be applied, but they were kicked out. And that gave way, I think, to this idea in some lawyers' heads that really what we'll do is we'll throw as much stuff against the wall as we possibly can, and leave it to these good people to find what's relevant. But between that process and me and us throwing that stuff against the wall, we have to filter it out. So what are the rules of evidence? Do we remember them? if we don't remember them, then what we're going to do is we're simply going to throw this stuff against the wall, not knowing that it's an opinion, not knowing that it's a submission, not knowing that it's all these other things. Once upon a time, laboriously, we'd have to go through and say, I object, I object, I object, I object. But that's the way it used to be. I'm glad that's gone. But what's set in is a rot, I believe, a rot. So now it's a question of weight. Well, let's leave these guys to decide what weight should be attached to this piece of evidence. It's time to sharpen our minds, and it's time to really sharpen the pencil when we put it to paper, so that that embarrassment, frankly, doesn't continue. So, talking of financial statements, I'll broaden it to affidavits. What is an affidavit? It should really include some formalities that are required. It should be in a proper form. Take that as read. So you have to say who you are, where you're from, and the usual formalities. Though strangely enough, much of that is not really relevant, is it? Because it's already been stated elsewhere. But stick to the formalities. Once you get beyond the formalities, then it's solid gold real estate. Don't waste it. So what's evidence? Does anybody know what evidence is? Can someone tell me what evidence is?
Someone's got it.
Facts. Something that proves or disproves something in issue. So let me read something He was apoplectic with rage. Your Honour.
Conclusion.
True. I took it from an affidavit. He or she will remain anonymous. Apoplectic with rage. What happened back in 1943? Where did that come from? So if he's apoplectic with rage, don't say it. I can say that in submission. Your Honour, he was apoplectic with rage. Oh, was he? Yes, he was. Paragraph 3, paragraph 4. There was domestic violence, Your Honour. Oh, was there? Yeah. Paragraph 9, paragraph 12. It's really important. What is domestic violence? What is family violence? You have to have an idea of what it is if you're just going to state it. But the real key, I suggest, is what is it am I trying to prove here? And this is just solid gold real estate, whether it's property or children. Matters not a jot. What am I trying to prove? What do I want to be able to say, whether it's through a solicit, whether it's through your own mouths, or whether it's through counsel, that there was family violence? That's an issue in the case, family violence. How do we go about proving it? Sitting down with your client, saying, how so? And the client, to use a female for the sake of discussion, he punched me. He punched me. He punched me with a closed fist. I fell to the floor. I mean, do I need to say he was apoplectic with rage? I would imagine he was. That's what you're trying to prove. Write it in a margin for yourself. That is what you're trying to prove. That's the submission I need to make at the end of this trial or at the end of this interim hearing. Write it down. It's called an issue. Family violence, apoplectic with rage, whatever it might be. Drug abuse. How do you go about proving drug abuse? He was sky high on drugs, Your Honour. Well, where's the evidence for that? I just don't have any. I'm actually forbidden to say that under the rules. Rule 60...
Don't point at me.
Rule 60... Rule 64, I think it is, whatever it is. I'm actually forbidden to do that. So I need the evidence, or I can't say it. But the reality is that when you're filing an affidavit and you're putting that affidavit before the court and you want somebody to do a good job, it might be you, for your client, you need to be able to make the ultimate submission. And if you can't prove it, you can't prove it. And if you can't prove it, you cannot prove it. So you need to sit down with your client and you need to, example I gave, an analogy I gave earlier on, you need to shake that tree and see what falls out. The fruit that remains on the tree is good fruit. The stuff that falls is rotten. If you're trying to prove family violence, that's a significant allegation to make. Prove it. Don't even mention the word family violence. Why? Because you don't really have the evidence you're going to call it something you think it is. Prove it. And we forget to prove it all the time. Be brief, be concise, and be particular. So very often we will read affidavits time and time again that really just go on for many, many pages. trying to find the evidence, referring to we'll start with page 9. No, we'll start with page 1, because you've only got 1 page left now. And you choose. Imagine the embarrassment of appearing before a judge, and the judge says, choose your 10 pages. Well, that's what I have to do when I now receive, and I haven't, but when I now receive the 30-page document. So remember what evidence is, remember what the purpose of the document is. B, do your jobs, which really is reality checking your client. You reality check your client by asking what the evidence is. What happened, ma'am? He punched me. He punched me. We need more detail than that. If there is no more detail, there's no more detail. But did you go to hospital? I went to hospital. What happened there? I was x-rayed. Be careful about exhibits. You can exhibit all sorts of things, but you can also take them with you. And if they become an issue, you can supply them. So don't be thinking you have to exhibit absolutely everything. The family court's got a direction, no exhibits. Woo-hoo. Good idea. They could, sorry.
I wish we had that.
Yeah. And what's been said in the exhibit? Can that be taken out? Usually it's a letter. See the following 943 letters. Why? For what purpose? Take out the bit that is relevant. Cut and paste that little bit that's relevant and put it in the body of the affidavit. I disagree with some practitioners who say that you're telling a story. You're not telling a story. If what they mean by that is that you are joining the dots, then I'll go along with it, so that it flows. But some of the best affidavits I've ever read, especially in property disputes, there is no story to tell. They just bang, 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 bang. What orders are you seeking? I'm seeking this order, and it's justified by that statement there, that piece of evidence there. That's compelling stuff. Reading something like Mills and Boon is not compelling at all. Something we might do in our private lives, but otherwise we don't. Thank you. This drafted? Yeah.
Feel free to pick these apart too.
I think I have to pick this one apart, and this is a deliberate test on Bruce's part. There's a typo in there. Anyone spot it?
That's why you don't use headings.
That's why you don't use headings, yes. Yeah. It's, I got alarmed because he said, you're talking on this. I said, thank you for binding me. And I looked at it and said, that's not what. And he said, no, it's a typo. I said, you wrote a typo there, so we have to explain it. We can leave that to you. You've got the document, you can find the typo. But the examples are good. You've got the document, there's no point in going through it. No point in going through all of these. The next slide, thanks. A great example of an interim property matter. Next one, thanks.
The Strong.
Yep. Thanks. Bruce has mentioned Strong. There are other examples. A great example I once read, and I wrote it down because I thought it was fantastic.
While you're looking for that, it
Yep.
reminds me, don't waste time in your affidavit resetting out all the orders you're seeking.
Yeah, and that's another point. What orders are you seeking? So you see in the initiated application 30, 40 orders on an interim basis, and then you turn the pages and they set out exactly the same on a final basis. Your Honour, Her Honour says, what are you seeking? And Your Honour, it seems we're seeking about 35 orders. What, on an interim basis? And you look at the quality of the orders, they're really unnecessary. If you're trying to recover a child, recover the child. And swear an affidavit that justifies the recovery of that child. Why does the child need to be recovered? Never feel embarrassed to ask your client, so what? Because it elicits an answer that's going to help you. There was family violence in the house. So what? Now, I'm not making light of family violence, but ask the question, so what? Because guess what follows that? The child saw it. That's the significance of it. I'm not making light of family violence if a child didn't see it, but that's the point you're making. The point you're making is impact upon the child. Saves Her Honour saying, was the child present? No, the child wasn't present. Family violence is family violence. If a child is present, it might justify the orders you're seeking. What orders are you seeking? And I'm seeking order number 11, 15 and 23. That's it. That's all I'm seeking. You're not going to get 35 orders on an interim basis, unless it's by consent, and that might go up and get accepted. Where am I? 12. I'll have the next one, please. Know your judge. Important to know your judge, but sometimes you're going to find yourself in front of a judge you just simply don't know. So the advantage of knowing your judge is that each and every one of them are different. Sometimes they're very different. But the advantage you have, I suppose, of visiting a registry you don't go to very often when you're in front of a judge that you don't know very well, is exactly how I kicked off my little talk earlier on, which is the luxury of knowing that you're sitting on an affidavit that justifies absolutely everything you're seeking. That, believe me, is a luxury for counsel and indeed for you guys if you're standing in front of a judge and a judge is pressing you. So it's solid gold real estate. Use it carefully. We don't need a story. Get straight into it. It need not necessarily read like a novel. If it does read flowingly, great, but it need not. Can I make the submission? Can I make the submission that what are the issues? Family violence might be an issue. Can I make the submission? If not, you have to reality check your client or look over your affidavit, but he was in an apoplectic rage or something similar. Just is not going to cut it. It's flowery and really it offends the rules that once existed. But it's certainly going to offend me, and it's certainly going to offend the judges when they read colourful language like that. 14, thanks. Is that reality checking? I think I've probably done that. Remember this as well, that what are you trying to prove? Are you trying to prove, and there are great spectra in life, but sitting on that spectra is a clip around the ear hole. Dad clipped the child around the ear hole and it hurt him. On the great spectrum of allegations, it's probably not the heaviest of allegations. It's inherently more straightforward to prove. Whereas Dad committed an act of child sexual offence, or committed some sort of act of indecency against the child, or caused some sort of non-accidental injury, you really do need to sharpen your pencil there and start writing some stuff down. Again, I am forbidden, and particularly forbidden, to make the submission that a criminal offence or anything tantamount to a criminal offence has occurred unless I am on safe ground. Read the rules. They'll bind you as well, but they certainly bind us. So the more draconian the orders you are seeking, the more compelling the evidence would naturally need to be. Whether you call that Brigginshaw or whether you call that Section 140 of the Evidence Act, do look at them. They're really very important. Because if you don't, somebody's going to be breathing down your neck, and you'll be very lucky if it's one of us, not one of these. So do look very, very carefully at the nature of the allegations, and you really do need to sit down and do some work on these affidavits. 15, thank you. What's likely, what's unlikely? I think 15 and 16 blending together. I think you mentioned interim relocation. Was it interim relocation you mentioned? Whatever it might have been. What's likely? Be realistic. You as a practitioner have to be realistic. My client wants to move to Melbourne because she's met a really nice guy and she just wants to go to Melbourne. Your Honour.
Depends on how cute the guy is.
That's where the exhibits come in. Fair call, I'd go as well. All right, but really, if it's an interim relocation, seldom do they succeed. They do, but they need to be compelling. So they're compelling. Let's write some stuff down that's really going to matter. Because if it doesn't matter, don't write it down. Tell your client it's just not going to happen. You are wasting your money. You're going to save a lot of embarrassment, and you're not going to be wasting these guys' time. Very, very important to reality check on interim relocations. Change of primary carer. If there's little risk, what is risk? What is risk? What is an unacceptable risk of harm? What is the harm? Where is the risk? Your Honour, it's just not good enough. It just isn't good enough. And time and again, certainly since 2006, I don't know about others, but I've just watched things just get looser. So does this practice direction come as a surprise to me? Absolutely not. I wholly welcome it. The other thing about 10 pages is this. If you can do it in 6, and you might, don't then say, oh, let's just look for a little bit of padding. Don't be doing that, because that's just going to annoy judges and anyone who stands in front of a judge just as much as the usual 39-page affidavit. So say what you need to say, and if you can turn up 6 pages and only 6 pages and you've proven everything you need to establish the order that you are seeking, you've done a good job. So remember the orders that you're seeking. What am I seeking? I'm seeking interim relocation. I am seeking the recovery of a child. Drill down on that point. You don't need to say there was family violence, because if you can't prove there was family violence, you can't say it anyway. So what's the point of saying it? You really are wasting real estate. I can stand there and say paragraph 3 and 9 amount to family violence and significant family violence, Your Honour. Of course it does. Job done. Simple as that. And that's the information that you can hand us on a plate, or yourselves if you're in front of a judge, perhaps on a Friday afternoon,
Can I
he or
ask a
she's on
question?
day. Which go?
How do we get around the spousal maintenance issue? Because that can be quite urgent and need to be addressed. And if you're saying it's unlikely to be addressed in the first
Okay, all right.
So again,
It is inherent-
spectrums.
So sorry?
There's spectrums.
Yeah, it's inherently unlikely that there's going to be a disposal or a relief in that on that basis, on an interim basis. But really, what I put back to you is, if that's the case, you've got a higher hill to climb. So of course it can be done. Nobody is suggesting, not even Judge Spellican is suggesting this, that it won't happen.
If it's truly an urgent applicant, and there's provision in the Act for that, urgent spousal maintenance, if it's to cover an immediate expense, of course in hearing those applications, you don't have to pay the same attention necessarily, provided there's enough evidence to support it, the same attention necessary to looking at the respondent's financial circumstances. But it's for a limited period of time, it's for a specific purpose. So there's always the ability to do that.
So it's not given that it would never be considered? Just
Oh, no, not at all. Not at all.
If it's a relief your client is seeking, then sit down and address it. That is your job. Once you've addressed it, you may well turn to your client and say, you're nowhere near. I put this to some of my clients when they just want me to do something and they just don't want to listen to my opinion. First thing I say to them is, well, I'm going to give you my opinion, whether you like it or not, and then we'll decide how far we take your matter. For me, I'm perhaps a bus driver, and what I need to do is to get their rickety old bus with 3 wheels, one falling off, whatever it might be, through that really treacherous pass. I won't mention any judges, none of them in this room, I can assure you, but I've been there. I'm the bus driver. I may be a little tired, but I've got to get through your bus through that pass, and not once have you asked me whether or not I feel fit to get your bus through that pass. I mean, it is snowing, the roads are closed and so on. Nobody asks. This is what I want, this is what I want. And the thing is that the first filter, of course, is the solicitor. And there are too many solicitors, if I may say, who provide me with information and they've G'd the client up. Slade Jones, he'll get you that. Very nice of them to think that I can. But I can't. So what's my opinion on it? Well, sit down, I'm going to give you both barrels. Now that should have been done weeks earlier. But here I am, 5 minutes, there's a knock on the door. Judge Spellican is ready for you. Okay, what do you want? That's your moment. That's your moment. That's your acid test. So when you are sitting down with a cup of coffee and a sandwich, whatever it might be, and you're drafting an affidavit, you've taken some instructions, just forget the coffee, forget it. Think of standing in front of, again, judges are a spectrum. There are some easier judges, there are some harder judges, but pick the hardest. Pick the hardest who is tired, grumpy, and has just been wound up by one of those other applications. So there's your worst case scenario. And imagine your worst case scenario. Can I say this? Or can I make the ultimate submission that the child, or rather I, should relocate with the children to Melbourne to be with this particular man? Or to get away from that other man? Now you're on fresher territory. So I would never rule anything out. I think interim disposals for relocations are seldom. You've made them? Yeah, you've made them? Yeah, they're made. Succeeded a couple of times, but they are rare. So that's the main thing with these applications. To answer your question, very roundabout way of putting it really from on my part, that any application can succeed if the evidence is supporting. Tell your client, do your job, or I'm going to have to. And if I don't, they will. They certainly will. All right, I talked about section 69ZT, which really said that the rules of evidence shall no longer apply unless certain circumstances do apply. It's worth remembering that. It is worth looking at section 69ZT, subsection 1, where it sets out what's been excluded. Because that's the very place I take you. That's where the rot, I think, set in. So what used to be inadmissible now is admissible, and it is now a question of weight. Nothing's changed there because subsection 3, I think it is, possibly 4, I don't remember, basically says that the judge will attach, or the court will attach as much weight as he or she sees fit. So nothing's changed there. So why throw muck against the wall when you really, really don't have to and shouldn't?
That's the wrap up.
Is that it?
Yeah, that's the wrap up.
Goodness gracious me.
Right on time.
I was then going to tell my story, but I've already told my story. Consequences, very, very briefly. I know I've probably run out of time, and I'm on my 37th page, but there you go. Consequences are written out in black and white. But that's all judges can do. I think we really need to step up to the plate and say, well, look, we see that we're staring down the barrel of costs, we're staring down the barrel of losing out. Really, it's just not professional. It's just not professional turning up with material that is immaterial. It just isn't professional. I don't see it very often, but there is a trend that more is better. Submissions, now let's move from solicitor's world for a moment to counsel's world. How many times do we read written submissions? How many times do we read written submissions that go on for tens and tens of pages?
Longer than the affidavits.
Longer than the affidavits. Now, we did tease, both of us teased when we read I think it was 28-page document on how to do all of this, which the very point was 10 pages. So the irony didn't escape us, but the reality is that it's a very interesting document, because if we're to explain what that practice direction says, it's this: 10 pages, 5 exhibits, consequences, thank you very much, good night. That's what it says, but doing it is a very different thing. So that's what we've tried helping you with today, is achieving those 10 pages. It's easy to make a 39-page 10 pages. You throw away 29. But there's a proper way to do it, which is to punch, 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 punch. As I say, it doesn't have to flow beautifully. It does not. But it enables me to make the submission that my client is seeking certain orders, limited number of orders. We're on a paragraph that read, rather than the voluminous affidavits that we do read. What I was going to say about counsel's submissions are, of course, really I've been leaning on solicitors a little today, but the reality is counsel have slipped into it as well. We like to show off a little bit, we all know that, but we like to show off a little bit, so our first 5 pages are setting out the law. I think we're lured into that because we very often read judgments where judges, because the pressures of the full court perhaps, where they're obliged to set out all by the authorities, that, for goodness sake, why not exhibit the Family Law Act and say, look, I'm a judge, I know it. Prove I'm wrong. Prove I'm wrong. And that's the test. And it's not just proving wrong, it's proving wrong to quite a high standard. But there it is. That's my little annoyance with counsels. I'm deliberately saying it because we're as guilty as many solicitors and waxing lyric. But the reality is then that 39-page affidavit goes before the court. So do the 39 pages of submissions. And believe me, very little of that will be absorbed. It will be read, of course, but very little of that will be absorbed, because when your client walks through the door, how often do you say to a client, excuse me, ma'am, or excuse me, sir, you're not the only client I have today. Yeah? Well, aren't the judges entitled to say, Mr. Slade-Jones, yours isn't the only matter I've got today. You've got 15 minutes. Now we can do it. Now we can actually say, Your Honour, this is the order I seek. This is the, yes, I've read the affidavit. Thank you, Your Honour. And I seek those orders. How can I address Your Honour? You don't need to. Thank you. What does the other side say? Job done. And my job's done as well. Right.
So, at the end of the slide, you deliberately have question marks. Is it going to accelerate matters through the FCC? Don't know. Really don't know. Will we get earlier trial dates? out of this practice direction? Again, don't know. Will it contain issues? Hope so, but don't know. But we really think it will make us all focus on our advocacy skills a lot more. So, hope you've had some benefit out of this evening. Got Judge Spellican here for a little while longer. We're certainly going to be here for a little while if you want to ask us questions. Judge Middleton's got no choice because he's relying on me to drive him back home. So,
Can I just make a couple of very quick points? Maybe some tips, I suppose. Both speakers, excellent speakers today, have spoken about issues and identifying issues. There are many themes, I suppose, in applications for children that are quite common. One's obviously violence, and there are others. But it's not necessary for you to obviously, first of all, you shouldn't just make a statement like there was violence in the relationship, he was a violent person, he was an alcoholic. There needs to be the facts that support that claim. But what you can do in an affidavit is, for example, say, on an example of the violence was on the 1st of January 2015, the father or mother came home from the pub and he struck me 3 times on the face, and I suffered this injury and the children were there, the children were whatever. Then you can say that was a common occurrence or a regular occurrence, and leave it at that. You don't need to go through every time that occurred. Text messages. Goodness gracious. Again, and I'm talking to Steve earlier about this. You read them and then you flip over the page and then you see the first half of the text message again, or the second half. You don't know whether that was the first one, the second one, the third one. The suggestion, pick your best example of an abusive text message. Type the text out and put it in your affidavit. You can annex that text message so that it's clear that you've transcribed it appropriately. Then you can say, you might even pick a couple, then you can say, that was the type of text message that I received on a regular basis over this period of time. You know, I have the text messages available if need be. Okay, so that's an example. I'm not exactly sure, but I'm pretty clear, and Bruce has confirmed he understands this is the case as well, that the 10 pages obviously also applies to response affidavits. Now, that's a bit scarier, I think, when you're responding to an affidavit than when you're the applicant. But still, it will be, you might get some leeway in that respect. You don't need to reply to everything that is said in an affidavit. And also in trial affidavits, it's very difficult when you're reading a trial affidavit, but particularly an affidavit in an interim application, to go back to the paragraph. I refer to paragraph 9 and deny, or I don't know what a paragraph 9 says. Only respond to those things you need to respond to. Brian Jordan, many years ago in Coralbin at a conference, when he was a judicial registrar, gave a tip to everyone that I still remember, and that is, you don't necessarily even have to say, you might waste the words. You know, I'm not responding to every part of the affidavit.
Yeah.
Maybe that's wasting some words, but although it's only a few words, that's probably not going to make much difference. I deny the allegations of XYZ, just one paragraph, all right? You don't need to go through them all because you're wasting your words. Another tip might be that when you're the applicant, don't necessarily presume what the respondent's case is going to be, unless it's clearly something that you need to address in your application. It's always best, and when you're on your feet, first thing you should say, Your Honour, I know you're going to be concerned about this, but this is, obviously there are those things that you should address in your application, in your affidavit, but not everything that you think that they're going to say do you need to address in your affidavit, okay? Another really important tool, I think, and obviously there are always urgent applications when this isn't available. I know legal aid funding's difficult for subpoenas. But even if you can't subpoena documents, think about where is a document out there, not my client's document, but an independent document, a doctor's report attached to the affidavit of the doctor is better, a bank statement, a note in medical records, a drug test result, something like that. So it's always a good idea, and I often say to people, are there any subpoena? We're looking for something. We've got one story over here, one story over there, and when you're trying to make decisions really quickly, having a document, preferably an independent document, is of great assistance. Steve, I'd be interested to know if there are any other tips that you've got for...
Yeah, I agree wholeheartedly in that. Do you want me around the front?
Yes,
I wasn't expecting this, I'll pretend I'm wearing. Obviously, I agree with everything that's been said, but in terms of what Robin was saying about being brief and being concise, I think it's fundamentally important that you don't tell a story. I think I spoke at a PIPA conference once before, and I said, if your client comes in and wants to tell a story, send her off to 60 minutes. Because that's where the stories are told. Get to the point really, really quickly is really, really important. That independent objective evidence that Leanne just spoke about, I'm forever saying it in court. What have you got? Give me something. Have you got a police report? Have you got a doctor's report? Give me something, because they're the things that identify issues really quickly and give us something to hang on to. Rob, you asked about spousal maintenance. So spousal maintenance for funding litigation, those sorts of things, or just for living, can often be part property orders as well. So think about the order that you're going to ask for, and then show me the source. Where's the easy source? First few paragraphs. I want this, and he's got that, or we've got this. Awesome. It can happen because it's only this percent. Great. It makes it a really, really easy thing to do. So go to the next level.
And I mean, obviously, spousal maintenance applications get pushed to the bottom of the list when we've got a whole lot of... It's not to suggest we won't hear them, but if you are making an application and we can hear them, there's the urgent applications, of course, but we can hear them. Again, there's no need for a whole lot of information, you know, and there should have been some disclosure before these applications were even filed. So, you know, you can put in your submissions, if you're acting for the applicant, you can put in your submissions, you know, or attach to the affidavit or something. You can do it fairly briefly. So think again, if you're the applicant, you've got to prove that you can't support yourself. So, you know, again, independent evidence from employers or something. If you're the respondent, you can't afford it. Financial statements, really, really important that they're done. So often they're so clear that they're done by the client, not by the solicitor or barrister. So often it's clear the affidavits, people have sent them along to their client, because often you'll see, the affidavit will say, insert, violence, insert, you know. So it's clear that, and it's just not, frankly, it's just not good enough, you know, and why are you charging clients for bringing their own affidavit?
Talking of charging, another example I had, and we shared this earlier on, a particular solicitor, doesn't matter who he or she is, it's a he, that narrows it a little, but I'm not going to say any more than that. But he wrote an affidavit, and exhibited here too is the diary notes of my diary notes. They went on to some 30, 40 pages. They were tightly typed. So I played a little trick on him, and I asked him a question. I can't remember what it was, but it was along the lines of, can you believe this man killed their cat when they lived in Cairns? Can you believe that? He said, I know, it's terrible, isn't it? I said, it didn't happen, mate. It didn't happen. You didn't read it. Did you charge for this? Will I get paid to read the rubbish you've just given me? A diary entry. Now, there may be some importance in it. There may be a compelling reason. Why not just take it out? I think you can hardly cut and paste some handwriting, but put it in the body if it's important. But a diary entry, I spent hours and hours reading it, and I had the embarrassment then of having to stand in front of a judge and say, Your Honour, rely upon, oh dear, rely upon this thing here. I could barely pick it up. There were that many diary entries. Don't do it. Just don't do it. It's embarrassing, because it's your name and your firm sitting on the front of that document, and this man should have been embarrassed beyond belief to put his name next to that document. It's a sales document, arguably. Look how good that is. And when a judge says, thank you ever so much for that affidavit, it's very, very concise, to the point, thank you. It's nice to hear it, and when it does get said, others hear it. But thanks for your 140 pages. Which 10 pages would you like me to read? That's where you're going to start here. Good too.